When they were upstairs, what were you doing?
I was trying to calm the kids.
Both of them?
But yeah, well, mainly.
How was reacting?
He was very upset once we told him, because he slept over a friend's house the night before, and he just said, I'll never see him again.
Heart-wrenching testimony from John O'Keefe's mom. An emotional day in the courtroom in Dedham. So what does the jury think? We'll talk about it. Plus, Kerry, Karen, and Jen, all three women were in the car when they found John O'Keefe dead in the snow. So how Kerry Roberts testified is what's tipping the scales this morning. We'll discuss with our panel. Plus, this hour, the NICU nurse accused of breaking baby's bones is now facing even more charges. We'll talk about it. And defendant Stephan Sterns, the man accused of killing 13-year-old Madeline Soto, testifies at a pretrial hearing. It's all coming up next for you right here on Opening Statements. Good Thursday morning to you, my friends, or should I say happy Friday Eve. This is Opening Statements, and I'm your host, Julie Grant. I'm so glad you're here. We've got a great show planned with tremendous guests. So let's get it started as we always do. Have you grabbed that cup of coffee? It's time for my opening statement. It's been said there's no love like a mother's love. And we felt that love from Peggy O'Keefe. Officer John O'Keefe's mom was the third witness called by the Commonwealth of Massachusetts in the criminal case against John O'Keefe's girlfriend, defendant Karen Reed. And before the trial began, we did a salute to John O'Keefe here on Opening Statements with three of his dearest friends. And this morning, I think we need to salute Peggy O'Keefe. She is so strong, she is so resilient, and so courageous. After all the heartache and tragedy that she's been through, it is remarkable she's still able to keep moving forward. She's a mother, she's a grandmother, and now she's back to being a mother again to those two precious orphan children that belong to her daughter and her son-in-law, and then to her son, Johnny. Wednesday was the first time the world got to hear her speak, and we could see it was hard for her to do that, especially when it came to her children that she's lost. My friends, I got to tell you, I was amazed at the grace, the resilience, and the class that Peggy O'Keefe exhibited in that courtroom, especially after all the horror that she's endured. No parent should have to bury their child, let alone bury two of their children. Peggy O'Keefe has sadly been there, and she is still fighting. She's leading by example, and she's leading with a mother's love. May God bless her and her family as they continue the good fight to get justice for their beloved Johnny. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
I was holding my Glock, and she started just like coming up at me, and I just fired.
Why?
She was gonna shoot me.
And you were afraid?
Very.
In Vermont, we've got convicted killer Joseph Ferlazzo set to be sentenced this morning. He was found guilty of killing his wife, Emily, while on their wedding anniversary. Court's going to start up at 9 a.m. Eastern time. In Colorado, closing arguments expected in the rock-throwing murder trial for defendant Joseph Koenig. Court's going to start up in that case at 10:30 a.m. Eastern. And in Massachusetts, defendant Karen Reed's retrial resumes at 9 a.m. Eastern. And that is our top story. The Honorable Beverly Cannone set to make her ruling this morning as to whether a clip of defendant Karen Reed from the Investigation Discovery docuseries can come into the retrial. Now, this was argued right after the jury got to hear the heartbreaking testimony from John O'Keefe's mother.
So we started walking down the corridor, and as I'm walking down, I hear Karen Reed yell, "Peg, is he dead? Is he dead, Peg? Peg, is he dead?" And I just kept walking, and then I asked, I don't know who it was, a nurse or a worker at the hospital, and I said, what is she doing here? And she says, oh, she's being psych evaluated.
Did you ever have a chance while you were in the car to speak to the defendant?
Yes.
Please tell the jury about that conversation.
I asked her what happened, and she said, we went to a party. I left him there. I said, you just left him there? She said, yes, I just left him there.
Throughout the retrial, Special Prosecutor Hank Brennan has been playing video clips of defendant Karen Read ahead of the witness testimony. And in the video that the Commonwealth is trying to get in, you can see Karen mocking Mrs. O'Keefe.
And his mother leans over the kitchen island and says to me, I think he looks like he got hit by a car. He looks like he got hit by a car.
Now, the defense is arguing that the Commonwealth just wants to introduce this clip to make their client look bad. But it's their client's own statements. She's a party to the case. The rules of evidence allow statements by a party to be introduced. But this defense team is pushing back, saying it's way too prejudicial to let it in. So what should the judge do? I've got three great guests here with me to talk about it. Let's welcome them in now. I've got celebrity attorney John Phillips here. He does both criminal work and civil work. And we have the co-host of the Murder Sheet podcast back on the show, attorney Kevin Greenlee and journalist Anya Kane. Great to see you both as well. And you both podcasted about the first trial over the death of John O'Keefe. Excellent podcast. I highly recommend it. All right, so let's talk about what the judge should do with this video clip. I'm sure you all have some strong opinions here. John Phillips, start us off. Should the clip come in, yes or no, and why?
Yes. The Fifth Amendment is designed to prevent self-incrimination. But you waive all of that when you go on the news and you talk and you mock and you say all these things. And certainly there's a line that a court has to look at and say, is that more prejudicial than probative? Is this something that really doesn't add to the case? But here, it kind of straddles that line. It is going to make her unlikable, but she makes herself unlikable. And it gets into the impeachment of the defense in a way that there's a lot more to this than what we're led to believe.
Right, right, John. And you mentioned impeachment, and so here we have a contradiction that the state is looking to draw out here, as you all know, because backing up, we know in this documentary, Karen Read mocks Peggy O'Keefe and says that she leaned over the kitchen island and says that she thinks that John got hit by a car, and we all saw the way Karen delivers it. But when we saw Peggy O'Keefe on the stand, she said that never happened, that she never had that conversation with Karen. She said that she came into the house with her father. They went upstairs, did who knows what. She didn't see it. I could just hear them up there for about 15 minutes together. And there were no hugs, no condolences, nothing like that, which I also think is pretty stunning. Anya, when you hear that part of a story, being such a great storyteller, when you hear that, what does that say to you about the total picture here, that right after John's death, there isn't any moment of consolation with Karen Read trying to hug and show some love to her boyfriend's mom?
Yeah, absolutely. And thank you so much, Julie. I think it's really striking. I will say people might grieve differently. They might deal with shock differently. I think we need to account for that. But just that fact, the lack of love between Karen and John's family. And not only that, the fact that you have her discussing Peggy in such a mocking way on TV, I just don't think this defendant has any clue how she comes across to others. And it's going to be a huge detriment to her, because basically what I've seen described is she's narrating her own murder trial throughout this whole thing through these different clips. And I think it's going to harm her with the jury.
Right, Anya, I think you were spot on. She even characterized it as her testimony. And for anybody who isn't aware, it was Karen Reed who invited those documentary filmmakers to come in and film her. And we saw them. It was almost like they were, you know, taking somewhat of a victory lap before there was any resolution with the case. And so we saw the resolution was not a good one for them. She's on trial again. The Commonwealth isn't giving up. So here, I want to go back and play a clip of these arguments. And Alan Jackson was trying to get the judge to let it come in on a document, saying, well, just type up the statement. Don't let the jury see her. Let's take a look.
This is simply a wolf in sheep's clothing. They're trying to get it in because it makes my client look bad. They've just put on a very, very sympathetic and empathetic witness, John O'Keefe's mother, and they're trying to make my client, Ms. Reed, look bad.
The defendant should not be able to pick and choose which of her statements do not look good for her and do not look bad for her. She made the statements that are relevant to this case. It's not unfairly prejudicial. It's a statement that they embraced and they chose and they publicized, and it goes directly to the issue of conscience of guilt.
Oh, yeah, Hank Brennan, boy, he is sharp. He's not only saying it comes in as a statement by a party opponent, but by the way, Judge, once you let it in, we want to use it to ask for that consciousness of guilt instruction. Kevin Greenlee, last but certainly not least on this power panel, I want you to weigh in. What should the judge do?
The judge should absolutely allow this clip to be brought in. It is relevant. It's a statement she actually made. And the fact that a particular statement does not look good for one party in the case is by no means a reason to leave it out.
Right, right. The rules of evidence don't provide a caveat and say, well, if it's a statement where the person making it doesn't look too great, then we should exclude. All right, so we're all in agreement. This statement should come in. And the judge asked for, well, not asked for, she basically said to the attorneys, I'm going to need some time. Presumably she's going to talk with her law clerk and decide what to do this morning. Okay, I have another clip for you both from that investigation discovery documentary. This one has already come in. Let's take a look.
I also wondered, did I say could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that, so the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming?
All right, John Phillips, your thoughts on that clip that the jury's already received?
Client management, client management, client management. You know, I had a client call, and I love you if you're watching this, but she demanded a press conference. And we've got other issues with deck actions and defense attorneys and other things. And I'm like, now's not the time. Let's there's time to use the court of public opinion, but let me win your legal case a little further down the road, you know, before we do so. And that's the problem when you have, you know, a borderline narcissist that's, you know, presenting her case so flippantly. When it involves the death of somebody and somebody she loves and others love, you would expect there'd be more sympathy, empathy, and you know, moments of reflection, not this. But I think the more the jury watches of this Discovery ID special, the more that the prosecution is going to, you know, be in you know, tipping the scales.
Right. I'm with you, John. Anya, let me go to you, please. Something I really appreciated in the episode you did about this case was you talked about how terrible it was and unacceptable, the abuse that was inflicted by should we say, the mob on Peggy O'Keefe and others in the O'Keefe family and in their circle of friends. Knowing that, I'm curious how you were watching the testimony yesterday and your thoughts that you walked away with after seeing Peggy on the stand, Anya.
Honestly, Julie, it broke my heart. I mean, this is a mother who's been through the unimaginable, losing not only John, but before that, her daughter. And, I think it's important that we want to see vigorous defense from defense attorneys and them really defending their client, going to the wall for them. But there's a difference between that and basically just taking a strategy that, you know, teams up with unscrupulous bloggers and just bashes innocent people in the court of public opinion for no reason. And you know, the the net effect of that has been the O'Keefes have been dragged through the mud. They've been booed showing up to court. I mean, it's just totally, totally unacceptable. And I just think it's just caused needless suffering that shouldn't have happened.
You're so right. Anya Kane and Kevin Greenlee, you two are incredible storytellers and well-respected members of the true crime community. Your podcast is The Murder Sheet. For any of our courties who haven't listened, you got to go do that. And guess what? We're so fortunate to have Kevin and Anya back at our 9 o'clock hour for the start of the case. So we'll look forward to talking more. John Phillips is staying with us here on Opening Statements and want you to do the same. When we return, coverage continues on Karen Reed's retrial.
When the EMTs were around and they were working on the body, she was running around and saying, did I hit him? Did I hit him? Is he dead? Is he dead?
So how will John O'Keefe's friend, Kerry Roberts' testimony tip the scales? Plus, the NICU nurse accused of hurting premature babies now facing even more charges.
Is Karen Reed a killer girlfriend?
She's guilty.
Or the scapegoat in an elaborate cover-up?
Karen Reed was raped!
Karen Reed is accused of murdering her police officer boyfriend.
And it's stated repeatedly, I hit him, I hit him.
She may end up taking the stand.
Her first trial ended with a hung jury.
They haven't proven anything.
Will a jury finally agree on a verdict?
We know who did it.
The Karen Reed murder retrial. Live coverage today on Court TV.
Somebody needs to be held accountable for my son, for everybody, others' kid. Like, somebody needs to be held accountable. It's too many in such a short period of time.
The former intensive care unit nurse accused of hurting premature babies is back trending in true crime because now she's facing 6 additional charges. Tuesday, defendant Aaron Strutman was served with 6 new indictments and now stands accused of injuring 4 different babies from 2022 to 2024. Prosecutors say she's also been charged in the treatment of a 5th baby, but that child wasn't injured. Scripps News reporter Melissa Hippolyte spoke with the prosecuting attorney who describes these shocking allegations at Henrico Doctors Hospital.
When you're talking about a process where mandated reporters are supposed to notify the agency who oversees whatever area that we're covering, and there's a failure to do that, that is always concerning.
Her office has still not brought any charges related to the 4 babies that were found with fractures in 2023, but she said detectives are still diligently investigating those cases.
We're getting there. I can't get into the details about what the process is that we may be engaging in as to why we are going forth and presenting the 23 babies in a different way.
Cameras were installed in the NICU at Henrico Doctors Hospital after those babies' injuries were discovered. That video evidence has helped prosecutors charge Strutman in connection with the 2024 babies. But even without video evidence, Taylor said they were confident bringing charges related to the 2022 baby.
A judge has allowed Strutman to remain out on bond, saying that the new charges were of lesser concern pertaining to bond because they occurred prior to the pending matters already before the court. She's due back in court in May. The tentative trial date is set for February 9th, 2026. We're asking, though, should the bond be revoked in the wake of the new charges? The judge saying no, because it's part of the same course of action that got her here in the first place. But one of the rules of bond is you can't pick up any new cases. What should the judge do? You all know how I feel about this. I never thought she should have been out in the first place. So let's talk about it. Let me bring back in Attorney John Phillips and welcome in Attorney Michael J. Brown and Dr. Sue Kornbluth. Good morning to you all. Michael, let me begin with you. You're a high-profile criminal defense attorney, once was a prosecutor, so you can understand the prosecutor who might want her back in jail. What should the judge do here?
Good morning, Julie. Good morning, everyone. The ultimate issue on bail in our world is to secure the defendant's attendance in court. So although it may be repulsive that she's out of custody and everybody wants to see her behind bars because everybody prejudged the case and the allegations are obviously horrific, ultimately, if she's reporting to court, if she comes to each of her court dates, if her ties to the community are significant, and she has already posted whatever bail she posted, probably not a reason to change the bail status. And keep in mind, Julie, I know that there's new charges, but my understanding is these all predate her arraignment on the initial charges. So if that's the case, she may very well pay the piper when it's all said and done. But as long as she's coming back to court, I don't see a reason to change her bail status, quite frankly.
Sure. Michael, appreciate it. Excellent points. Excellent points. Sometimes we may not like it, but the law is the law. And with her out on bail, we know that there are strict conditions in terms of monitoring. My understanding at last check, she was staying with her parents. It's not like she's free to do whatever. John Phillips, you know this is a media case. You have many media cases. Would you look at this, please, from that perspective of this defendant and the eyes being shined on her? Your thoughts on the bond, please.
I had a similar case where we had one or two parents with an abusive pediatric dentist. And the media got a hold of it, and next thing you know, we had 10, we had 30, we had 100 over the course of decades. Some didn't have a civil statute of limitations. Some didn't have had an expired criminal statute of limitations. But, you know, the process worked through, and media helped because one parent sees another parent and said, "Oh, this happened to my child as well," and you know, it's the recidivism here. You know, certainly there's not going to be future if she's not working for a hospital, but there's enough on a victim standpoint, you know, with children with broken femurs, tibias, and ribs, that it's particularly malicious. It's particularly, you know, offensive, that I think the court could go either way. You could be Mr. Brown's more strict interpretationalist of the Constitution and say, but she's going to appear. But on the same token, you know, her acts are pretty disgusting, and charges of child abuse and malicious, you know, with maliciousness in the title, could warrant, you know, no bond as well.
Certainly. John, thank you for all of that. I know we all detest these charges, these allegations. I want to turn now away from the legal aspect of it to the psychological aspect and what may have been going on. Dr. Sue Kornbluth, I know you've been digging into this case. You have a lot to say about it. For anybody wondering who could possibly do something like this, how might you answer that question, please?
Well, this screams to me that this is somebody that clearly has mental health issues, but probably was abused herself. And she doesn't have a voice to express probably what happened to herself. And she's preying on the most innocent of victims here to hurt them, which are these precious, precious little babies. Now, there is a history, which I read, Julie, that she has a background of using cocaine and also was seeing a psychiatrist. I don't know what she was seeing a psychiatrist for, but cocaine, you know, can make you do things that you wouldn't normally do. What hurts the most here, I think, is for these parents who are going through this. I mean, this is their babies. They want to protect them no matter what, trusting in the system that a nurse wouldn't hurt their child. So my heart goes out to the parents, and I also believe that she is somebody that needs severe, severe help. And to me, Julie, this is just such a horrific, horrific story of abuse on so many levels.
Dr. Sue, you're so right. This is all extremely helpful, everything you're sharing. And I want to dovetail off of something you just said about how your heart breaks for the parents. And so as this criminal process rolls on for defendant Aaron Stratman, these parents may be left wondering, does the buck stop with that defendant?
It was intentional, it was child abuse, it was the most severe level that it can be, and that kind of like definitely opened our eyes to it, because nobody had ever said that before. Nobody had ever said, this is child abuse, this was intentional.
Henrico Doctors Hospital initially put Stratman on paid administrative leave in 2023 after an internal investigation was done. This after babies linked to Stratman's care showed consistent injuries. But the hospital didn't report those injuries to CPS. So after Stratman was arrested, Henrico Doctors Hospital released this statement saying in part, quote, "We're both shocked and saddened by this development in the investigation and are focused on continuing to care for our patients and providing support to our colleagues who've been deeply and personally impacted." Goes on to say, for more than 30 years, the NICU at Henrico Doctors Hospital has provided necessary and life-saving care to babies in Central Virginia, and we remain focused on ensuring the availability of that care in our community. So this morning we're wondering, is the hospital at all responsible here? John Phillips, you do a lot of civil work in your practice. What do you say?
This was my face when you were talking about that. It was a big old eye roll. You know, I see this all the time. You know, I'd certainly advise the victims to watch out for words like intent, because it'll invalidate insurance policy coverage and create a mess there. But absolutely the hospitals on notice of this. Absolutely. You know, the first time an incident happens, you know, under neglect laws, there's a little bit of protection for a defendant. But by the second, third, fourth, fifth, sixth, seventh time, you know, certainly they're on notice. They're doing nothing. You know, you're not going to be able to introduce cameras necessarily because they were post-remedial measures, you know, things put in, and the law says let's encourage that, not discourage it. But you know, certainly there's civil liability on the hospital.
Right. John, thank you for that. Dr. Sue, let me go to you here, please. I know this case has you fired up. When you think about the hospital and what they could have possibly done to prevent this, I'm sure you've got a lot of thoughts. By all means.
Well, we've seen this so many times, Julie. I've talked about this a lot on the show as well. When you see something, report it. It is not for you to determine as a citizen or anybody if it is abuse or not. If it looks like abuse, or if it looks like it's something that shouldn't be happening, or somebody's being hurt, call it in. And it seems that the ball was missed here, that somebody knew what was going on. It wasn't called in. And that father is absolutely right. It could have prevented this from happening over and over and over again. This goes back to what we know as the innocent bystander effect. Everybody thinks somebody else is going to do it. But in most cases, that's not what happens. If you see it, report it.
Exactly. Dr. Sue, you're a fierce protector of children. We really appreciate the psychological expertise you've shared with us. Thank you for all of that. I know we need to let you get going. Attorneys Michael J. Brown and John Phillips are coming with us. We've got more legal matters to discuss. Here is what's next on Opening Statements.
During your contact with law enforcement, did they seize or take an item from you?
Yes, they did.
What item was that?
That would be my cell phone.
Looky here. We've got the man accused of killing this beautiful 13-year-old girl testifying in court, Madeline Soto. She is the victim here, and the man accused of sexually abusing her and killing her testified in a pretrial hearing. You're going to hear it next. And we're talking about the emotional testimony from John O'Keefe's friend, Kerry Roberts, how she may tip the scales with the jury.
I'm pretty sure you know what some of those pictures are about. You're a very intelligent person. And I don't want you to discredit yourself by saying you don't know about all the pictures that are on your phone. I want to let you know you're not free to leave. You're being detained, okay? Do you want to know what you're being detained for? Capital sexual battery and possession of child pornography.
Defendant Stephan Sterns is in the spotlight this morning after he made a rare court appearance where he testified. This is in an effort to have some key evidence against him suppressed from his upcoming sex abuse trial. So Sterns is accused of abusing and killing 13-year-old Madeline Soto. She was the daughter of his girlfriend, Jennifer Soto. They were all living together. And investigators zeroed in on Sterns after allegedly finding pornographic material on his cell phone, reportedly including Madeline. But his lawyers argue the deputies unlawfully took his phone from him, violating his rights against unreasonable searches and seizures. Here's what Sterns said in court, and we want to give you a warning. The audio quality, unfortunately, isn't the best.
And Mr. Sterns, did you come into contact with law enforcement in February of 2024?
I did.
During your contact with law enforcement, did they seize or take an item from you?
Yes, they did.
What item was that?
That would be my cell phone.
Do you know what type of cell phone it was?
It was a Samsung Galaxy, I believe it was a 24.
And what was your understanding, if any, as to what they were going to do with it?
They were just going to check my Google Maps and check to see if I was logged into Google, and that was it. That was all I agreed to.
Were you shown, or did they have a warrant?
They did not.
The judge said he would make a ruling on this at a later date. So let's talk about how they got the phone in the first place, the story here at play, and then also what legal decision the court should make. It will have big implications on the upcoming trial, no doubt about it. Let's bring in Court TV digital content producer Lauren Silver and criminal defense attorney Michael J. Brown. Let's start with the story. Lauren, I want to start with you, please. So would you kind of back us up way back to how investigators looked at the phone in the first place and saw the alleged pornographic material?
Right. So after Madeline was reported missing, she hasn't been found yet. We just know that she has disappeared, and his story was that he had dropped her off at school, and that was the last time he saw her. He gave police a lot of information about where he'd driven that day, so they wanted to look at his phone to see if his maps matched up with that. So they asked him if they could look at his phone, and they were standing next to him while they did that, and they looked through the maps, and they could see that the maps did not, like his phone data didn't match with what he had been saying. So they then went to go check surveillance cameras, get some more information, and as they were standing next to him, they said, can we look through your phone? Can we look at your history? They weren't specific about what history they were looking at. And they did wind up determining that, one, there were pornographic images on the phone, and two, that he had performed a factory reset on the phone.
Ruh-roh. Okay, so he tells them that they can look, and then they see some very, very bad things. At that point, Lauren, I want to be very clear. At that point, they still did not go and get a warrant, did they?
Correct. They told him, we want to keep your phone. They said, we're going to keep this. He said, well, I'm going to need to call my dad. They said, well, you can use Jennifer's phone for that, but we're going to keep this and make a copy overnight. And either you can consent to giving it to us, or we can get a search warrant. And he was like, okay, well, then take it. So they never got a search warrant. He did consent to them taking it, and they did wind up keeping it overnight, but they never received a search warrant for this phone at any point.
Lauren, thank you for that. Boy, this is like a law school problem. Michael J. Brown, what do you say here? Legally, are they good to introduce this evidence, or is there a problem? Should they have gotten a warrant at the point in time that they saw the first pornographic images involving children?
Julie, they're good. When you have consent, they have an absolute right, the law authorities do, in order to go through that phone. So if the defendant consents and says, you can get into my phone, you can look at it, that gives them carte blanche, basically, to look at the phone. Obviously, if it's conditioned on what they can look at, which doesn't seem to be the case here, then they're limited. But having said that, a lot of police departments and district attorney's offices, even though they get the consent and they start looking and seeing things, they still may get a judicial warrant, because then they cover their bases. And then this whole issue kind of gets put to rest because they also have a warrant. But in terms of the legality, once you consent, they absolutely have the right to search that phone. Game over.
Right. Michael J. Brown, thank you for that. You took the words right out of my mouth about how it's even better if you get a warrant too, right? Like you've been a DA, you know how it is when police may call you and say, what should we do? We're at this juncture. You advise them, cover all your bases. But as you said, this seems like this was a valid consent, and Sterns doesn't have a viable argument. Matter of fact, we have the moment where police ask him for his permission to look through the phone. Let's play that clip. Here we go.
From what I understand, that you gave the deputies consent to look through your phone. You did? Okay. And you voluntarily gave it to them so they could bring it here to do the extraction and stuff like that. Okay.
Oh, okay. So clarifying, it wasn't the first moment, but the second moment where they're going back to the first moment in time. Lauren, when you see his disposition there, and you've been watching him throughout these court hearings, you've been writing great articles for us on courttv.com. Was there a difference when you see Sterns in that room a moment ago versus what you saw yesterday in the courtroom?
Not really. I mean, his appearance has certainly changed. The beard is not quite as full. His hair is much shorter. His stature looks a little different. But he has a very nonchalant demeanor. He was described that way by police at the scene. Also, when they were interviewing him and taking his phone, he seemed very calm. He noted that he had taken a Ativan, which is a relaxant the night before, but he has never seemed too uppity. The volume was overmodulated and it was difficult to understand him, but he was calm, he was articulate, he answered the questions appropriately. He's not too chatty, but always calm, even demeanor.
Consistent. Lauren, thank you for that. Michael J. Brown, do you find it at all weird that the Florida prosecutors are going for the sex abuse case first, and second, they're going to try the capital case for Madeline's murder?
No, I don't. I think that they have the strong case here. They have it on his phone, Julie. They have the evidence on the phone. I think it's a very strong case. And then they can move forward from there. And the conviction actually may be used against them during the next trial. So I think it's a good move.
Oh, that's interesting. Do you think that could be the strategy there, Michael, to get that conviction to introduce?
I would hope they have something behind their thought process.
Yeah,
Yes.
something. No, I know. Great analysis from you both, as always. Lauren Silver, I know we've got to let you go. Thank you for everything for coming on this morning. We'll see you very soon. And coming up next on Opening Statements, here's what we've got.
When I got to the hospital, both eyes were swollen with, it looked like blood. They looked purple.
Is that how John looked?
Yes, he did.
Oh my gosh, we're looking at Kerry Roberts' testimony, digging deeper into the relationship between Karen, Kerry, and Jen.
No, you're dodging the question, David. You're dodging the question.
I'm not here to be interviewed. You've agreed to be interviewed. You told the police you shot him twice in the head. It sounds like you lost control of yourself.
Not at all. No, not at all. I could have killed everybody in the building, and I didn't.
You think you should get some kind of credit for not killing people?
Interview with a Killer. New episode. Sunday at 8 on Court TV.
Welcome back. Now for what's tipping the scales in defendant Karen Reed's retrial. John O'Keefe's friend, Kerry Roberts, gave some very emotional testimony on Thursday. And we know that Kerry Roberts, Karen Reed, and Jennifer McCabe were all in a car together when they drove up to 34 Fairview Road and found John O'Keefe dead, covered in a mound of snow. Kerry Roberts testified that her friendship with Jennifer McCabe really started from the trauma of that event and bonding through it.
You told us that you had only met Miss McCabe once before that night?
Yes.
And after that night, shortly after what happened, did you speak to Miss McCabe again?
Yes.
How often?
Very often. We wanted to know what happened to our friends.
For somebody who was not your friend, why did you, at this point, form this close bond?
I think because we went through something horrific together. We bonded over it.
Yeah, they really didn't know each other. But through that event, you know, the common denominator is they loved their dear friend John O'Keefe. And so these women kind of stuck together through all of this. And what an ordeal it's been. Let's bring in our legal eagles to talk about how Kerry Roberts' testimony may have tipped the scales of justice for the jury. Michael J. Brown and John Phillips with us every Thursday morning. We love that. Tell me, how did you feel after Kerry Roberts got off of the stand? I'm curious the impressions you were left with and if any of the emotion hit you hard. Michael, may I start with you, please?
Julie, I think she did a good job. I like what she had to say and the way she said it. But this Alan Jackson is a real good lawyer, and he did a nice job on cross-examination. And, you know, one of the things that was concerning to me as a defense attorney is he brought out the fact that she had testified falsely in front of the grand jury about this Google search and hypothermia. And that's important because, you know, in New York State, we have this falso in uno, I think it's called. And the basis behind that is, hey, if you testify falsely about one issue, you could consider that they would have testified falsely about everything. And that's really the theme that Jackson's going to go with, that they're just getting together and making this all up. So he's doing a good job, but I thought she was an important witness for the prosecution.
Sure. And Michael, as you know, it's the defense argument that she testified falsely, where she was trying to explain that she didn't hear the end of Adam Lally's question, that she was trying to just relate what she says she learned happened, not what she heard. So she kept saying, I didn't hear it, I didn't hear it. I'm not saying that I heard it. If I misspoke before the grand jury, then I did. I obviously didn't hear it, not trying to lie. John Phillips, do you think she was believable in that the jury thought it may have been that she misheard, wasn't trying to mislead, or do you think that the defense painted her successfully as testifying falsely as they have argued?
I do think she was believable. You know, Michael's using Latin. I use Mama's rule. And Mama's rule is a liar's a liar and a cheat's a cheat. And so you can take somebody that you've caught in a lie and extrapolate that they have a tendency not to be honest and trustworthy. And that's in life, you know, generally. But she did, you know, jurors also understand that we misspeak, that cross-examination can trip us up. And it's the body of the testimony that they'll listen to, and then they'll be reminded at closing argument, by the way, you know, there was this inconsistency, and they'll hammer it home, but they're entitled to do so. Overall, I think she was, from what I saw, and I have my own cases, so I didn't watch the whole thing, but she was very sympathetic and a good witness for the prosecution.
John, appreciate your thoughts on that. We know that the third woman in the car that evening, and again, Karen Reed roped both of these women in, called them in the middle of the night. They're John's friends, not her friends. She woke Jennifer McCabe up, and Jennifer McCabe gave testimony last year. Also, through her, the state got in the admissions of Karen Reed saying she hit John. Let's take a look back at Jennifer McCabe last year.
You indicated that the defendant said, I hit him, is that correct?
Yes.
That's something that she said once or more than once?
3 times. I hit him, I hit him, I hit him.
All right, and I'm sure we can expect the same when she is called in this case. Michael J. Brown, tell me, when we think big picture being painted, the Karen Reed defense is that the collision never happened. Never happened. Do you think that's going to be a successful defense for them?
I don't, Julie. You know, the beautiful thing for the prosecution, number one, Brennan's a great lawyer as well. And what's happened when you do it the second time is you get to perfect everything from the first go round, and you have all the transcripts, you get to polish things, you get to change things, you get to refine it, and you can do it better the second time. So he's really doing a great job, and I think he anticipates obviously what they did about the first trial, and he's heading a lot of that off on the second trial. And I think he's doing a good job, and no, I don't think it's going to matter.
I'm with you. I just, how can you deny, you know, like I quoted Frank Reagan from Blue Bloods the other day, facts don't cease to exist simply because you choose to ignore them. Great show, isn't it? John Phillips watches Blue Bloods. He's clapping. You guys are the best. Michael J. Brown, John Phillips, thank you for the great discussion today. We'll see you next Thursday.